Welcome back to The Deep Dive, the show where we give you that shortcut to expertise straight from the dense source material. Today, we're digging into something really fundamental and intentional torts, something that flips the script a bit. Usually we're all about the plaintiff proving the wrongful act, the battery, the trespass. But what happens when the defendant basically says, yeah, I did it, but I had a good reason? We're talking defenses to intentional torts.
Exactly. Normally, it's all about proving the tort happened. Today, it's about proving why it was okay even if it happened. And the crucial thing, the absolute key, is the burden of proof. Once that plaintiff makes their case for the tort, boom, the burden flips. It's entirely on the defendant now to prove they had a valid defense, a privilege.
Okay, so these aren't just technicalities, they're actual justifications. What are the main defenses we need to get our heads around today?
We'll focus on three big ones. First up is consent, basically. The plaintiff said it was okay. Second, self-defense. And that umbrella also covers defending other people and defending property. And third, we have necessity, which is when you do something seemingly wrong to prevent a much greater harm.
All right, let's jump into consent. Sounds simple, right? They agreed. But I suspect it's trickier than that. What's the core rule here? Is it about what the plaintiff really wanted deep down or what it looked like they wanted?
Well, this is often the first big surprise for people. Generally speaking, consent is judged objectively. It counts as a defense if the defendant reasonably relied on how the plaintiff acted on those outward signs, even if secretly the plaintiff is thinking, no way.
Hold on. So if someone says yes, but maybe they're crossing their fingers behind their back or looking terrified, the defendant can just ignore that if the word was yes. That objective standard feels a bit off.
But there's a nuance. You're right, it's not that simple. While the main focus is objective action, the defense falls apart if the defendant knew the yes was fake. You can't hide behind consent you actually know isn't genuine. The reliance has to be reasonable.
Okay, that helps. Let's test this objective idea with implied consent. The classic case, right? The steamship vaccination one. O'Brien v. Cunard.
Perfect example. Let's analyze O'Brien v. Cunard SS Com. First, what are the legally dispositive facts?
Right, so the plaintiff, she's a passenger on a steamship. She gets in this line with other passengers who are getting shots, vaccinations. When it's her turn, she holds out her arm, doesn't say anything, and gets the shot. But later, she says she didn't actually want it, didn't intend to consent.
Okay, and what was a core legal issue?
The question was, did her actions, getting in that specific line, holding out her arm objectively, show implied consent, even if she didn't mean it?
What rule did the court apply here?
The court said consent is implied when someone's conduct, just looking at the circumstances, reasonably signals permission. What they're thinking inside doesn't matter if their actions say otherwise.
And the court's analysis, how did they apply that rule?
They reasoned that, given the context, everyone knew what that line was. For her actions of joining it and presenting her arm would lead any reasonable observer, like the doctor, to believe she consented. Her secret feelings were irrelevant to the doctor's reasonable perception.
Makes sense. And the final conclusion?
The court concluded her actions objectively showed implied consent. So the vaccination was privileged and her battery claim failed. Okay, so consent needs to be objectively manifested. But even if someone gives consent, it can still be invalid if the defendant goes too far, right? The idea of scope, how does that work, especially in tricky medical situations?
Exactly. Scope is critical. The general rule is super strict here. Consent is only valid for what was actually agreed to. If the action goes beyond that agreed scope, consent evaporates instantly. And in medicine, this is huge. An unauthorized procedure is a battery. Doesn't matter if the doctor thought it was needed or even did a great job. No consent, no privilege.
That sounds potentially scary for patients. Let's look at Moore v. Williams. This is the case where someone consented to surgery on one ear but woke up to find the other ear had been operated on.
Precisely. Let's analyze Moore v. Williams. First, what are the legally dispositive facts?
The patient explicitly consented to surgery on her right ear. But while she was under anesthesia, the doctor decided the left ear actually needed the surgery more urgently and operated on the left ear instead.
And what was the core legal issue?
Did the doctor commit battery by operating on the left ear when consent was only given for the right ear? Did he exceed the scope?
What rule did the court apply?
The rule applied was straightforward. Any medical procedure done without the patient's express consent is a battery. Good intentions or medical necessity don't override that lack of consent.
And the court's analysis? The analysis was pretty direct. The authorization was solely for the right ear. Operating on the left, no matter how medically sound the reason seemed to the doctor, was simply outside the boundaries of the consent given by the patient. And the conclusion?
The conclusion was that the physician was liable for battery. It really highlights how strictly the scope of consent is interpreted. But then how do we square that with a case like Kennedy v. Parrott? There, a doctor doing appendix surgery found cysts on the ovaries and punctured them, apparently to avoid a second major surgery later. That was found to be okay, wasn't it? Why the different outcome from more?
Yeah, Kennedy represents a sort of necessary exception or refinement. The court in Kennedy viewed puncturing the cysts not as a different operation, like in Moore, but as addressing an unexpected issue within the general area of the authorized surgery. They saw it as reasonably necessary to deal with an immediate complication discovered during the approved procedure, arguably falling within the implied scope of handling unforeseen problems to avoid greater risk later. It wasn't switching the primary target like in Moore.
Interesting distinction. Okay, besides exceeding the scope, what else can invalidate consent? Let's quickly cover incapacity, like kids or someone heavily intoxicated.
Right. Minors, people deemed legally insane, or someone severely intoxicated, generally lack the capacity to give valid consent. But here's a key point. If the defendant didn't know, and couldn't reasonably have known about the incapacity, the consent defense might still hold up.
And fraud. You mentioned the rat poison in the pizza example earlier. It has to be fraud about something essential.
Exactly. Consent is invalid if the fraud relates to the fundamental nature or essential character of the act itself, like putting poison in food. But if the fraud is about something collateral, a side issue like lying about the brand of pepperoni, the consent to the touching itself, the eating of the pizza, likely remains valid.
Okay. Lastly, illegality. What if two people agree to something illegal, like a back alley fight? Can the loser sue the winner for battery, or does their consent block the suit?
This is a split. The traditional majority rule says, nope, you cannot legally consent to a criminal act. So, in that illegal fight, consent wouldn't be a defense in a tort suit. But the restatement and a growing minority take a different view. They say consent is valid unless the specific criminal law broken was designed to protect the person consenting, like a statute preventing minors from prize fighting. In that case, the consent is invalid because the law's purpose is to protect that very person from their own decision.
All right, let's shift gears to self-defense. This feels very primal, the right to protect yourself. What are the absolute must-haves, the core requirements to claim this defense?
The general rule here has two main pillars. First, the person must reasonably believe that force is necessary to protect themselves. And second, the threat they're facing must be immediate, like right now. And it's not just one or the other. You need both a genuine subjective belief, and that belief needs to be objectively reasonable under the circumstances.
Okay, reasonably believe. What if you reasonably believe you're about to be attacked, but you're actually wrong? Are you still covered? And how does the amount of force play in? That seems critical.
Good question. The law does protect reasonable mistakes in this context. If you reasonably but incorrectly believe you're under attack, you can still claim self-defense. It's about your reasonable perception at the time. But the amount of force is strictly governed by the reasonable force rule. You can only use the force reasonably necessary to stop the threat. And critically, deadly force likely to cause death or serious bodily injury is only justified if you reasonably believe you're facing a threat of death or serious bodily injury yourself. You can't say, shoot someone just because they're about to punch you.
Let's make this real. Imagine A starts a fight, kicks B hard. But then A immediately backs off, hands up, yells, okay, I'm done. B is furious, chases A down, and shoots A. Is B acting in self-defense?
Absolutely not. Zero justification there. The rule is crystal clear. Retaliation is not self-defense. Once the initial aggressor, A in your hypo, clearly stops the attack and communicates retreat, the immediate threat is gone. B's right to self-defense ends right there. If B continues to attack, B becomes the aggressor, and A might actually gain the right to self-defense against B. Immediacy is key.
What about running away? Is there a duty to retreat? If someone's coming at me with deadly force, do I have to try and escape if I can do it safely?
The duty to retreat. This is a major split between jurisdictions. The majority rule, often called the stand your ground rule, says no. If you have a legal right to be where you are, you do not have to retreat, even if you safely could. You can meet deadly force with deadly force. However, the minority rule, which is also the position of the restatement of torts, says you do have a duty to retreat before using deadly force if you can do so with complete safety. The main exception is if you're inside your own home, the castle doctrine. This rule reflects a policy choice valuing human life over the right not to back down. #4B, defense of others.
Okay, what about jumping in to help someone else, the Good Samaritan scenario? Can you use force to defend a stranger? And what if you mess up? Like you think you're stopping a mugging, but it's actually an undercover cop making a lawful arrest.
Yes, the law generally allows you to use reasonable force to protect a third person from what you reasonably believe is immediate unlawful physical harm, so you can intervene for a stranger. But the mistake scenario, that's where we see another split in the rules. The older view, the limited privilege rule, is sometimes called the step into the shoes rule. It means the intervener has only the rights that the person they're defending actually had. So if the person being rescued was actually resisting a lawful arrest and had no right to self-defense, the intervener is liable for battery, even if their mistake was totally reasonable. Tough luck, basically.
Ouch. That seems harsh on the Good Samaritan. What's the other view?
The more modern approach found in the restatement rule is more forgiving. It grants the privilege to defend others if the intervener reasonably believes the third party is entitled to use self-defense. Under this rule, a reasonable mistake is excused. The policy debate is whether to prioritize encouraging intervention, even with the risk of mistakes, or to strictly limit force to situations where it's actually justified. The restatement favors encouraging help.
All right, let's turn to defending property. How is this different from defending a person? Specifically thinking about the level of force allowed and what happens if you make a mistake.
The differences are huge and really important. First, you can only use reasonable, non-deadly force to protect property. Never, ever deadly force just for things. Life is valued more than property, period. If someone is stealing your TV, you can't shoot them. Second, and this is crucial, when it comes to protecting property, there's generally no defense for reasonable mistake against an innocent party. If you use force against someone you think is stealing but they're actually innocent, you're liable for battery, even if your mistake was reasonable. Unless, maybe, the innocent person somehow caused your mistake, it's much stricter than self-defense.
That brings us to things like booby traps, the famous spring gun case, Cutco v. Brainy. Why are mechanical devices like that treated so harshly? They set up a shotgun trap in an abandoned house they owned.
Because mechanical devices are indiscriminate and dangerous, the rule is that you can only use a device intended to cause death or serious bodily injury if you, personally, would have been justified in using that same level of force if you were present. Since you can never use deadly force just to protect unoccupied property, setting up a deadly trap like a spring gun is almost always unlawful. It can't distinguish a thief from a lost child, it can't give a warning, it can't adjust the...
Okay, what about getting your stuff back after it's been taken? Recovery of personal property or chattel. Can you use force then?
Only in very limited circumstances. You generally can only use reasonable, non-deadly force to recover property if you are in hot pursuit of the person who just took it, immediately after the taking. And again, you act at your peril regarding mistakes. If you chase down and use force on the wrong person, even reasonably thinking they took your wallet, you're liable. The main exception here is the merchant's privilege. Statutes often allow store owners to detain someone they reasonably suspect of shoplifting for a reasonable time and in a reasonable manner to investigate. This privilege does usually protect merchants from liability for reasonable mistakes. Hashtag be necessity.
Okay, last big defense, necessity. This is the one where you interfere with an innocent person's property rights to prevent something worse from happening. What are the different types?
Right. Necessity comes in two flavors: public necessity and private necessity. Public necessity is when someone acts to protect the community as a whole from a major disaster. Think fire, flood, disease. If you damage private property for the public good in such an emergency, like blowing up a house to stop a fire spreading, Sirocco v. Geary, it's a complete defense. You owe nothing. Private necessity, on the other hand, is when you interfere with someone's property to protect your own private interest, or the interest of a small group, from a greater harm. This gives you an incomplete privilege.
Incomplete privilege. What does that mean exactly?
It means you're privileged to enter or use the property. The owner can't legally use force to kick you out while the necessity exists. But, and this is the key, you are still liable for any actual damage you cause to the property. You have to pay for what you break, even though you had a right to be there.
Let's break down a private necessity case then. Plouffe v. Putnam, the one with the boat and the dock during the storm.
Classic example. Let's analyze Plouffe v. Putnam. First, what are the legally dispositive facts?
Okay, the plaintiff is out sailing with his family. A sudden violent storm kicks up. To save themselves and the boat, they quickly moor the boat to the defendant's private dock. The defendant's employee, his servant, then comes out and unties the boat, casting them back into the storm where the boat is destroyed and the family injured.
And what was the core legal issue?
Did the plaintiff have a right, under private necessity, to be moored to the dock? And if so, was the servant's action of untying the boat wrongful?
What rule did the court apply?
The court applied the rule of private necessity. It creates a privilege to reasonably interfere with another's property to avoid a serious threat of harm to life or property. And crucially, the property owner cannot use force against someone exercising this privilege.
What was the court's analysis? They reasoned that the storm created a clear necessity for the plaintiff to use the dock to protect his family and property from a much greater harm, potential death, or serious injury. This necessity gave him a temporary right to be there. The servant's act of untying the boat was therefore a wrongful use of force against a privileged person. And the final conclusion.
The court held the landowner was liable for the damages caused by the servant's wrongful act. The plaintiff's necessity trumped the landowner's property rights in that emergency. Okay, that covers property well. But necessity is about choosing the lesser evil, minimizing loss. It makes me think, what about extreme situations involving life itself? There was that old criminal case, United States v. Holmes, where sailors threw passengers out of an overloaded lifeboat to save the others. If necessity justifies property damage to save lives, could it, theoretically, justify taking one innocent life to save many?
That is the absolute outer edge, the most difficult ethical and legal question surrounding necessity. While the defense usually applies to property interference, the underlying logic minimizing overall harm does raise that grim possibility. Could sacrificing one save 10? Legally, applying necessity as a defense to intentional killing or serious bodily harm is incredibly controversial and rarely, if ever, successful in modern law, especially outside extreme survival scenarios. But the philosophical question remains potent. Hashtag tag outro.
Wow, so consent, self-defense, defense of property, necessity. It really comes down to objective actions, reasonable beliefs, proportionality, and sometimes who bears the cost of a mistake. It's not just about whether the defendant did the act, but whether the context made it justifiable.
Exactly. And to help you navigate this on, say, an exam or just analyzing a situation, here's a kind of step-by-step checklist in order to think through these defenses. 1. Always check consent first. Was there an objective manifestation of permission? If yes, great, but then immediately scan for invalidators. Did the action go beyond the agreed scope? Was there fraud about something essential? Was the person incapacitated, and did the defendant know or should they have known? Was it an illegal act where consent is void? 2. Then look at self-defense. Was the threat perceived as immediate? Was the force used proportional? Remember, deadly force only for deadly threats. If deadly force was used, what's the rule on retreat in that jurisdiction? Did they have to retreat if they could? 3. Consider defense of others. Did the intervener act on a reasonable belief? Okay, then which rule applies? The old step into the shoes, limited privilege rule, mistake, liability, or the modern restatement rule, reasonable mistake is excused. 4. Defense of property next. Crucially, was only reasonable non-deadly force used? And remember, the strict rule on mistake. If force was used against an innocent party due to a reasonable mistake, the defense usually fails unless it's the merchant's privilege situation. 5. Finally, check for necessity. Was the interference needed to prevent a significantly greater harm? If it was public necessity, saving the community, it's a complete defense, no liability. If it was private necessity, saving oneself or a few others, it's an incomplete privilege to be there, but must pay for any damage caused.
That framework is incredibly helpful. Okay, one last thing to chew on as we wrap up. We saw the law is often willing to excuse a reasonable mistake in self-defense, or defense of others, at least under the modern rule. But it almost never excuses a reasonable mistake when only property is being defended against an innocent person. Why the difference? Why is the law more forgiving of potentially harmful mistakes when protecting people compared to protecting things? Something to think about. Go explore.